As we saw in the first two segments of this module on environmental justice dispensation, it was true that the higher judiciary came up with a path breaking effort in rendering environmental justice beyond the rule book and contributed immensely to environmental jurisprudence. But as we saw towards the end of the last segment, that strains were beginning to show the weariness on the part of the higher judiciary, the difficulty in tackling highly complex environment related issues started taking its toll, and also the kind of reactions that started coming, which was initially like a whisper, started getting louder, of the judiciary guilty of overreach. Be that as it may, developments started taking place in both finding an appropriate formula of a solution in the form of a relief for those who get affected by environmental accidents because there was no formula. The courts were actually coming up with their own custom made formula for each occasion. So, the need for evolving a formula for compensation in such instances of suffering on account of an environmental damage being caused, industrial accidents taking place, etc. And second, the need for specialized bodies. In the next two segments, that is what we precisely attempt as to what these developments have been at the lawmaking level and working of that law. First, we will examine the formula that was worked out for getting environmental relief by way of compensation expeditiously, quite unlike as it happened and as it continues to haunt our system, the Bhopal gas tragedy. And that was the Public Liability Insurance Act, and it was followed by an institutional creation through another law, the Environment Tribunal Act. First, we will begin with the Public Liability Insurance Act, PLIA. The law was made in the year 1991. What exactly is its background? The growth of hazardous industrial operations and the increasing incidence of putting the lives at risk with little legal support for relief. The symbol of that, the most tragic one at that, was the mass disaster of Bhopal gas tragedy. And you know how the litigation went on for a long time and still alive to some extent even now at the highest court level. There was a very clear expression on the part of the Supreme Court, especially with regard to inordinate delays for relief to the victims. The court was very keen and insisted the government to evolve a robust legal frame to ensure speedy dispersal of compensation to industrial victims and creation of an industrial disaster fund. But the court did not leave it at that. It's not just about immediate relief. But what is the basis for that kind of a relief? And for that, the Supreme Court even provided the broad contours of such a kind of a principled basis in the legislation, and they insisted that it should be anchored to what is referred to as no fault liability principle. We will discuss that as we get into the details of this law. The result of such a constant demand expressed by the highest court, work began in the ministry, leading to the making of the Public Liability Insurance Act in 1991. It makes it very clear at the outset why for this law has been brought into existence. Obviously, to provide immediate relief to persons other than the workmen in that place who are affected by accidents occurring while handling hazardous substances through an insurance amount paid by the owner of the hazardous substances. Let's quickly have a look at what does this law contain, its salient features. As I did mention, it is anchored to the principle of no fault liability imposed against the owner of hazardous substances and the operations resulting from that. It requires the owner of a hazardous substance must have an insurance policy for a claim for compensation for injury to or the death of any person on account of any hazardous substance. And this is very important, please note, that is where no fault liability exists, without going into any requirement of establishing fault on the part of the owner. This actually describes an accident. An accident is an unforeseen event, unplanned event, unintended event. That's why you call it as an accident. You did not want that to happen. You did not visualize that happening. There is nothing like a premonition of an accident happening. You did not plan that to happen, but it happened. It's a mishap. Earlier, one would escape any kind of liability by claiming an accident. And here, the idea is the very fact that you're in possession of a dangerous object, which has the potential of causing harm, and so whether it actually causes harm or not, whether it actually gets snatched away from you and somebody suffers on account of that, the very possession of it will impose a responsibility on you and you become liable should any mishap were to occur. So intention, motive is inconsequential. That's why it's called no fault liability. You are not at fault. It just happened. But it happened because of the fact that you had that with you. Of course, you did not release it. Of course, you did not desire that it should have some kind of create some kind of a problem to somebody, but it just happened. The very fact of it happening and somebody suffering is enough to make one liable. No fault liability. Every owner of a hazardous property, before handling the property in advance, should take an insurance policy by which he gets insured against the liability over monetary claim for relief. Now, who can claim relief? Number one, the person who has sustained the injury. Number two, the owner of the damaged property. Number three, the legal heirs or representatives of the deceased person. And finally, the authorized agent of all the above ones. Any application for claim or relief under this law has to be made to the district collector, the executive magistrate of a particular district. Within what time? Within 5 years of the occurrence of the accident. And how would the quantum of relief calculated? The collector makes an inquiry, and after holding wide-ranging consultations and inquiry, he will determine the quantum of relief. So, it is not that you are going to a court for relief, you are making an application to the collector, from whom you are going to collect the relief. The quasi-judicial authority, the executive magistrate, the district collector, would be performing the task of justice dispensation to you through this. The award is binding on the parties and the insurer, and the amount shall be paid within 30 days from the date of announcement of the award. So, the idea of an insurance policy is very clear. That in the absence of an insurance policy, what would have been the plea of the one who has been responsible for somebody suffering? I do not have adequate cash. I do not have enough money to pay. And to checkmate that, this insurance requirement has been brought in that you should have it in advance with you as a kind of necessary preparation for you before you start the operations. That means you'll have to be extremely careful, and even with that care, if something happens, you have to pay. And to reduce the burden on you, you plan for payment in advance by paying to the insurance company. And it's the responsibility of insurance company to process the application and follow the instructions of the district collector of the exact amount of compensation payable to the one who has suffered injury or has lost property or damage of his property on account of this. The penalties for violations. Supposing the order is given that you need have to pay so much of money by way of compensation, the executive magistrate's order is like that of a court of law. That's why it's called as a quasi-judicial authority. And supposing one defies the order and does not follow the orders, then the law clearly provides for imprisonment that may extend to 3 months to 7 years, and a fine which may range from 1,000 rupees to 1 lakh rupees. This is over and above the money that's payable by way of compensation. In order to make things easier and streamlined, an environmental relief fund, there is a provision under this Act, Section 7, which requires establishment of what is referred to as Environment Relief Fund, ERF, by the central government to provide immediate relief to victims of accidents under this Act. This was notified in the year 2008. The law was made in 1991. Although the provision was there in existence in 1991, it took 17 long years because even the insurance companies were taking a lot of time in paying relief under the garb of a number of enquiries and clarifications that they wanted to seek, with the result that there used to be even then delays in compensation payment. And so Section 7 made it very clear that quick, immediate relief is something that's called for, and it is incumbent on the government to establish a relief fund. And it became a reality in the year 2008. And it has been, by way of statistics, made available till the end of last year, till early last year, March 2019, the total amount that was created as a corpus has grown from 283 crores to start with to 810 crores, and a lot of relief was immediately, without delay, were paid. And please note that the relief given under this Act is definitely in addition to the relief that may be awarded under the National Green Tribunal Act 2010. What does that mean? We have a specialized justice dispensation mechanism established after 2010. I'll be discussing that in detail later. Suffice it to say for the time being that from 2010 onwards, a very regular, professionally organized, expert infused body is established which would deal with environmental issues and then decide on them, and there some compensation may be awarded there. The relief that you get under this particular law through the payment of insurance money is and immediately paid out of the environment relief fund. These are immediate reliefs, and this is a thing that has to be paid whether other kinds of reliefs are going to be made available or not later. But this is an immediate relief, assured relief, and the Public Liability Insurance Act is still in operation now. Any relief that's being given under any other law is independent of that, and nothing would offset anything here. Please note, this act is a risk covering mechanism and a frame evolved for securing relief for those affected by hazardous substances and operations. The law does not create any new separate institution for securing relief under this law. If the relief is denied or not adequately made available as a normal process, then we have a formal legal process provided under this based upon a principle of no fault liability, and through which one can get the relief, immediate relief for the trauma that one had to go through on account of an accident of the description given under this law. So it is to act as a kind of a shock absorber. The other reliefs are in addition to this. That should be noted. Let us just move on to another law that was made. While Public Liability Insurance Act is a wonderful device, a tool, principle, and a mechanism to seek and secure relief, we have another law which attempted to create an institutional arrangement for environment justice delivery, the first major national attempt in the form of National Environment Tribunal, created under the National Environment Tribunal Act of 1995. National Environment Tribunal Act. What is this about? We have heard about National Green Tribunal. Is this different from that? Yes, this is different from that. Is it still in existence? We will see about that. And that's what I intend discussing it right now. Let us just look to the background and what are its principal features, and then look to the question that was raised, its current status. Is it still there? Remember, I had discussed with you very early in this course a very important case decided by the Supreme Court of India in the year 1986, referred to as the oleum gas leak case, which actually laid down the principle of absolute liability. Please recall, a liability that is there on the part of someone who, on account of his activities, for whatever reason, is going to cause harm, alarm, injury, and loss to somebody. He will become absolutely liable, no exceptions. That's why it's absolute liability, not an ordinary liability which has exceptions, but absolute liability without exceptions. And in giving this decision and laying down this principle, in this particular case, the Supreme Court had directed setting up of a national environmental court to provide relief from the damages caused by the handling of hazardous substances. At that time, the Supreme Court was headed by Justice P.N. Bhagavati, and he retired very soon after delivering this judgment. And it was this justice who had suggested for the setting up of an environmental court, and when the government asked him to prepare a draft and help them in that exercise, he prepared a draft bill also for the government which included establishment of a court at two levels, national level and at the state level, very similar to the consumer redressal mechanism under the Consumer Protection Act, whereby two-level grievance redressal mechanism exists for consumers who have either had a problem with a defective object or suffered a deficiency of service. Under those two circumstances, they initially go to the state authority which would decide on this, or at the next level go to the national one. So on similar lines, a proposal was made, the draft bill prepared, and that was there with the government for a while. And in 1995, the National Environment Tribunal Act came into existence. What does it contain? Well, it has 31 sections having elaborate provisions for the establishment of a National Environment Tribunal with benches within it to hear and decide upon compensation for the death of or injury to a person and damage to property and environment caused by accidents in handling of hazardous substances and activities. Look at the composition. It comprises of a chairman, a vice chairman, and a number of judicial and expert members. Judicial member we can understand. Somebody who is drawn from the judiciary, primarily from high courts. After their retirement, for a particular period of time, they could be nominated and they become a judicial member. Who is an expert member? An expert member is someone who has academic and research qualifications on certain areas of specialization that have a bearing on environmental management, conservation, sciences, and subjects in relation to that. And it just works like a court of law. In the High Court and in the Supreme Court, there are several judges. But to hear a case, you will have what is called as a single judge bench, two judges bench, or a number of judges sitting in judgment, like division bench or anything like that. The more important cases, which requires a larger number of judges to sit and deliberate and decide, they will have what is called as a divisional bench. Full bench is the entire court. All the judges sit together and then hear the case and decide. Normally this happens in constitutional cases, issues concerning constitutional amendment and things like that. Anyway, just like that, as it happens in Supreme Court or in the High Court, the National Environment Tribunal also functions in benches. And there is a very, very specific requirement that in each bench, which decides a problem independently and separately of the other bench, there is a mandatory requirement that each bench shall have an equal representation of a judicial and a non-judicial expert member. That means it cannot be one member becoming a judge and then deciding an issue in the bench. It should have at least two members or multiples of two. But the basic requirement is each bench should comprise of as many judicial members as there are expert members. So judicial and non-judicial ratio is equal. So for one judge, one expert. Two judges, two experts, like that. The idea is essentially on matters pertaining to points of law, the judge will bring in his skill. On matters pertaining to sciences and expertise in certain areas of environment, the non-judicial expert member who is adapting those issues will sit and deliberate, and together they give the decision on behalf of the National Environment Tribunal. It is not bound by the procedures of Civil Procedure Code. It is free to lay down its own procedures. The award of the tribunal to be executed just like a decree of a court of law. If you do not follow, if you do not respect, if you do not comply with its order or word, it's punishable with imprisonment extending to 3 years or with fine that may go up to 10 lakh rupees or with both. If one is aggrieved to the decision given by the Environment Tribunal, the appeal from its decisions would lie with Supreme Court. A very impressive law made in 1995. Did it deliver any judgment? Did it decide any case? What has been its contribution to environmental justice? The answer comes in the next few lines. Number one, this law that was made in 1995 got repealed by the National Green Tribunal Act. Okay. So from 2010 onwards, this is not there. Yes. It was there between 1995 to 2010. Yes. What did it do? Well, I must say this act remained in hibernation for 15 years. Have you heard of that? Make a law with so much of preparation, but never bring that into existence? Actually, that's a fact. No appointments were made when the law was made to occupy the members of the tribunal, membership of the tribunal, not just for 1 year, 2 year, or anything like that. No chairman was nominated when offer was made, and that's through the recommendation of the Chief Justice of India. The very person who was requested to take the mantle declined, and so there was neither a head, the chairman, nor members to this body. The ministry did not really actually fill in the positions of membership, and so it remained only on paper, hibernated for 15 years, and became extinct after that. A forgettable, non existent, and inconsequential footnote in the annals of the evolution of environmental codes in India. A very pathetic state of affairs. If the state was not serious in bringing a specialized court into existence, a tamasha or a drama was created in 1995. But actually, in terms of content, there was nothing much problematic about it. It was pretty good. Only thing is, the government did not really proceed further other than making the law. From paper to practice, it never graduated into. And so, no case law, nothing to discuss about it, except stating that it provided the inspiration for the making of the National Green Tribunal much, much later, 15 years hence.